Welcome to Beg to Differ, the Bulwark's weekly roundtable discussion featuring civil conversation across the political spectrum, from center left to center right. I'm Mona Charon, syndicated columnist and policy editor at the Bulwark. I'm joined by our regulars, Damon Linker of The Week, Bill Galston of the Brookings Institution and the Wall Street Journal, and Linda Chavez of the Niskanen Center. Our special guest this week is Eugene Volokh, Gary T. Schwartz, Distinguished Professor of Law at UCLA and founder of the legal blog, The Volokh Conspiracy. Professor Volokh is the author of a textbook on the First Amendment and many law review articles. An immigrant from the USSR at age 7, he graduated from UCLA with a degree in math and computer science at the age of 15. Professor Volokh will be sitting out the first segment and joining us later in the program. And we want to jump right in with the momentous news of the verdict in the Derek Chauvin trial. It was arguably a momentous moment in American history. It's very, very difficult to get a conviction of a police officer. So, Damon, I'm going to start with you. Is this possibly a unifying moment? The polls show that the vast majority of Americans believe this was the correct verdict.
Well, I certainly hope so. But, as the kind of jaded cynic I am, I'll say I'll believe it when I see it. And by see it, that means more than the first couple of days after the verdict. And the main reason why I'm a little skeptical in the longer term is because, as is a frequent theme on this podcast, the right has decided that its interests lie in denying the justice of the verdict and seeing this as some kind of a triumph of left-wing mob rule. And, we'll see. We'll be able to tell within the next week or so if the right backs off that narrative because they're seeing from their constituents and in polling that this actually is not helping them. But if you watched Tucker Carlson this week, of course, the big star now on Fox News, and gauged, the statements of lots of Republicans, what we saw this week was a travesty that this poor police officer who was doing his duty with a criminal who had taken a fatal dose of drugs and was bound to die anyway, any minute. And he's now unjustly been railroaded because of those terrible far left destructive protests last summer, combined with statements of Joe Biden and Maxine Waters, which I should add, I didn't think were the best move. Waters especially, I think, was totally outrageous, and some of the things she was saying before the jury was sequestered for deliberations. Biden's statement also kind of coming out before the verdict to say, in effect, what he thought the proper verdict should be was also unusual and not a great idea, civically speaking. But, clearly Biden's comments, which were made while the jury was sequestered, had no effect on the outcome. And Waters, I'm sure, didn't have much of an impact either, though we may hear from them again on appeal for Chauvin. But in the end, we're dealing with another iteration of the same story that we see these days, that the Republican Party has decided that its interests lie in always seeking division, always ending up on the opposite side of whatever the center left and left think, even when it concerns a matter of deep injustice that most Americans recognized the moment they saw that video of Chovin kneeling on George Floyd's neck 11 months ago. So again, I hope that you're right, and this is a cause for hope, but I'm concerned that that might be a little naive to think so.
Linda, following up on Damon's points, some of the responses on the right have been just really remarkably cruel and also fact-free. So you had Scott Adams, who was one of the chief Trump defenders saying there's a fine line between justice and human sacrifice. The obvious implication here being that the Chauvin was the human sacrifice here to appease the mob. And another one tweeted, George Floyd's death will go down as the most consequential drug overdose in history. In point of fact, the issue of Floyd's drug use came up and was debunked. Not that he used drugs, but that it caused his death very thoroughly during the trial. These comments, and especially those on Fox News that have so much coverage, they dealt with as the Trump people would put it, alternate facts.
They certainly do. I mean, there are two universes now, Mona. We live in a universe of people who get their news exclusively through Fox News Channel, OAN, and Newsmax. And they live in a world in which they saw virtually none of the trial. They don't read articles that actually deal with what the medical examiners found, what various experts said. They simply hear this drumbeat of, defense for Detective Chauvin, who showed no remorse, did something that I think all of us could see with our own eyes. I mean, we're talking about 9.5 minutes of a man who has his knee on the victim's neck. The victim is pleading, saying he can't breathe. He's clearly in distress. And there are bystanders around, including police. And, this trial was just one of several trials that will be held, because some of the officers who stood around and did nothing to try to come to George Floyd's aid will also have to face a court of law. But if all you're hearing is the Fox News, Tucker Carlson story, then you believe that this police officer has been railroaded. And I think that's really, it's really scary, because this is a deeply race-driven narrative. It is the innocent white police officer against the big, scary, drug-addicted black man who is, just by virtue of being those things, a criminal in the eyes of the people who watch these shows. And it is an old narrative. I mean, these are the kinds of incidents that in the past were used to justify lynching. It's really deeply disturbing that there is a portion of the population who is getting this very distorted view of the world and not seeking any alternative explanation and not using their own eyes. I mean, that 9.5-minute film taken by a young teenage girl who recorded it all is widely available for anyone to watch. And it is very difficult to watch, but apparently Tucker Carlson doesn't think so.
Yeah, that's true. And look, people, sometimes you can sort of sympathize with people who are getting only one side of the story and think, well, it's not their fault. They're misinformed. It's the fault of Fox News or whatever for misinforming them. But, in this case, I actually do think that people who seek out a narrative to erase what their eyes saw are culpable too, right? I mean, there are times when you just have to say, you know what, this was so obvious. Anyway, let's move to let's move to Bill Galston, because there are moves now for reform on the as a consequence of this. The George Floyd Justice and Policing Act passed the House in March. It would do a number of things: ban chokeholds and carotid holds, increase police training. I want to talk about police training for a minute, Bill, because It's amazing when you look at the police departments on average require officers in the United States to complete 672 hours of basic training before joining the force. To become a barber in many jurisdictions, a person must go through 1,300 hours of training, according to data from the Institute of Justice License to Work study. Is that one of the areas that we need to improve?
Well, sure it is. It is. It's hard to look not just at the George Floyd case, but all of the cases we've been reading about without uh, without coming to believe that police are not adequately trained in techniques of de-escalation, something on which Senator Tim Scott has had a lot to say, or other forms of violence avoidance. Uh, it appears often that the resort to force is the first resort and not the last resort. It appears that in many cases, the police are more interested in defending themselves than they are in avoiding unnecessary harm, either to innocent bystanders or to the alleged perpetrator. Uh, when I was in the military, the training I received uh, included, as a point I think I made last week, included the fact that I was sometimes precluded from adopting tactics that would maximize my chances of surviving with my life without injury, in deference to the interests of others who might be caught up in the combat. Uh, so this is one of many areas where we need fundamental reform. And let me just make a broader point about this moment. We can argue forever about how this verdict is being received and interpreted in different quarters. The fundamental question is what we do to change laws, structures, and institutions. We have a moment now, a point that both Karen Bass, negotiating for the House Democrats, and Tim Scott, negotiating on behalf of the Senate Republicans, have made in the past 48 hours. If we're serious about making progress, we will get to yes on a compromise version of the kind of bill that Senator Scott championed last year and has reintroduced, and the George Floyd bill, which has passed the House of Representatives. And this is a time for the President of the United States to show that he means business about bringing the country together. Because if this moment passes with no legislation agreed on and enacted, I think it will be a colossal system failure, and some of the fault will be attached to the president.
Yes. I would just add that some of the things that are under consideration are ending qualified immunity, reducing the legal standard of liability from willfulness to recklessness, providing a national registry for bad cops. This could be so important because very often cops have moved from one jurisdiction to another, and the new people do not know about their history, and that is kept private. So these things could all be important, and also reducing the levels of military grade equipment that so many police departments have taken to using. It's very psychologically unhealthy, it seems to me, for a democracy to have its cops outfitted like commandos.
Well, the good news is that Senator Scott is actually quite upbeat about the prospects of negotiating compromises on all of the outstanding issues, which he says are only 4 or 5 at this point, suggesting that agreement between Democratic and Republican negotiators has been reached on most of the items you just mentioned. Not qualified immunity, because that's the toughest one, but
Mhm.
many of the others.
Which is really actually, I mean, that's we should exhale here and say this is a moment. I mean, we've had such despair about the possibility of bipartisanship on any subject, and this is a fairly fraught one. And if we can reach it, that would be tremendous. Um, all right, let us now turn to our second topic of the day, which is the view on the right that we're seeing that we need to change our um, libel laws and that we need to change our standards about the freedom of the press. Um, Both Justice Thomas and appeals court judge Larry Silberman have offered that they believe New York Times v. Sullivan, which is sort of the backbone of protections against for the press against public figures suing them for libel, ought to be reconsidered or even overturned. And Judge Silberman went so far as to call the current construction of the press a threat to American democracy. So I'd like to welcome Eugene Volokh and ask you, what do you make of this? And is this a departure for these conservatives from their traditional views on these matters?
No, this is actually part of a long-standing view, not just among conservatives, that the right to reputation, the right not to have your reputation damaged by falsehoods, is an important part of personal dignity, also an important part of stopping fake news, of making sure that the public debate is based on accurate statements, and that can coexist with the freedom of the press, as it has throughout American history, with some degree of protection for the press, but also some degree of recovery for plaintiffs. Now, I actually don't quite agree with Justice Thomas and Judge Silberman that the current rule should be changed. But it is a very traditional approach. I will tell you, the most prominent advocate of cutting back on New York Times v. Sullivan on the Supreme Court was not a conservative judge. It was Justice Byron White, he was a Kennedy appointee, but long seen as a centrist on the court. And he, in case after case, said, look, New York Times v. Sullivan, which he actually joined when it first came down, when he was a very new justice, went too far. That by saying that you can own that public officials, and then extended to public figures who might not be government employees at all, that by saying that they can only recover for libel basically over deliberate lies, not over negligent falsehoods, however negligent, that was going too far and under protecting honest public debate and under protecting reputation. Again, I actually think that where the court has ended up is probably better than the alternatives. Like what they say about democracy, what Churchill said about democracy, it's the worst possible system except for the alternatives. But again, I think the position that Justice Thomas and Judge Silberman, and before them Justice White and some other conservative justices, Berger and Rehnquist at times, for example, took is a perfectly plausible position, because you have to consider a reputation and protection against injuries to reputation, as well as freedom of the press.
Let me ask you a little bit about the public figure aspect of this, because it strikes me, I haven't followed the law closely, but it does seem to me that the definition of who is a public figure has really expanded, so that everyone is saying, for example, that now Dominion voting systems who experience libel and slander during the post-election period, and Smartmatic, that these are public figures because why? Because they provide a public good or something, but they're not public officials for sure. And what do you make of that?
Well, so New York Times v. Sullivan was a lawsuit brought by Sullivan, who was a government official. An official at a local government, but still a relatively high-level official within that government. But then, pretty quickly, the court extended that. This New York Times v. Sullivan was in 1964. Within the next few years, the court extended that to so-called public figures. And then eventually even to so-called limited purpose public figures, who are people who are otherwise private people but just get involved in some debate. So there are basically 4 ways you can become a public figure. And again, the important thing about a public figure is that you can't recover for damage to your reputation from falsehoods unless they're deliberate lies. Merely showing negligence isn't enough. So there are 4 ways of being a public figure. One is being a public official, which is basically a government employee at a high up enough level. Another is achieving pervasive fame and notoriety. So that could be LeBron James, let's say, as a public figure. Everybody knows his name. Another is assuming an influential role in ordering society. So maybe some kind of titans of business, not just the ones who are also pervasively famous, like Bill Gates, let's say, or Mark Zuckerberg, but also maybe Larry Ellison, who I think runs Oracle, and maybe not as well known, but maybe quite influential. And I would think that big corporations, especially ones, either big corporations or corporations that are involved in providing essential government functions, like election services, I think they would qualify as having an influential role in ordering society. And then there are limited purpose public figures. Somebody gets involved in some debate about some local controversy, and then they become a public figure for purposes of statements related to that debate. So even an ordinary citizen can become a public figure if that person chooses to get involved in public life, and then people start making accusations about that person that are relevant to his involvement.
So, does that mean that last category? Does that mean that if someone libels you and you have not before been involved in public affairs or public life, and you defend yourself, you then are a limited purpose public official or a public figure?
Generally speaking, no.
Okay.
Generally speaking, courts say that your involvement has to predate this alleged libel. On the other hand, I suppose if you defend yourself and then go further and then start saying, oh, well, not only are the original statements against me false, here are the bad things about the person who has said them, then you might be starting up a new debate about the qualities of that person, and then
Right.
they could
So,
retaliate.
and what's your view about Dominion and Smartmatic? Do you think they will be declared public figures?
I haven't followed the briefing here, but my first reaction is if you want to look for an organization that has assumed an influential role in ordering society, I would think an organization that is providing election services would be a public figure. Now, note, by the way, you could imagine a situation where libel law only protects individuals. Because that's seen as sort of central to human dignity. But corporations, if it's an impersonal criticism, may be bad for their bottom line, but you might say that shouldn't matter. Now, as it happens, our legal rule is that corporations have the same right to be free from libel as individuals. Though, interestingly, government entities, the federal government, state governments, local governments, public universities, Indian tribes, those cannot sue for libel, because they're seen as it's kind of important enough that people should be free to say anything at all about them, including deliberate lies. But in any event, corporations under our law can sue for defamation. But I do think that courts are going to be more open to finding a corporation like that to be a public figure than an individual, in part, again, because these concerns about the special dignitary interests of individuals are less present with corporations.
Linda, do you think that free and robust debate in a democratic society requires a rule that you can only be punished for libel if it's outright malice, if it's outright lies that you knew to be lies, and not reckless flinging of accusations? Because that's what we've been living under.
Well, and I frankly think it's worked reasonably well. I mean, what I find interesting about this whole debate, believe me, those who are wanting to see New York Times versus Sullivan overturned are not there because they want to have Dominion Corporation be able to sue because it was defamed by Trump and his allies. They're certainly not thinking in those terms. And I think this whole debate, frankly, what has been troubling to me about it, and particularly troubling in terms of Judge Silberman, who's somebody I have long respected. I think he's played a very important role in conservative intellectual circles, but he went on a real tirade about the liberal media that I think is inappropriate for a sitting judge, that does not help the cause that he is advocating for. And it looks like he has, a horse in this horse race, rather than that he's simply being impartial and talking about the law and what can best serve democracy. I mean, for him to claim that there is such incredible liberal media bias, let's, set the record straight. Yes, there is liberal media bias. I think all of us on this panel could agree that the Washington Post, the New York Times, CNN, MSNBC all tilt center left. But there are huge audiences, as we were just discussing, for news organizations that tilt center right, or even far right. And so, for him to act as if that universe doesn't exist and hasn't, in many ways, counterbalance the influence of the so-called liberal media in this day and age, where you can pick and choose what source you want to get your information from based on your own ideological leanings. I don't think that he can claim that somehow the liberal media has a stranglehold on democracy. So I thought that was very unhelpful, and even unhelpful to his own cause. I mean, there may be, as Eugene Volokh has just suggested, there may be some reasons that we might want to take a look at libel laws and adjust them. But I don't think that Larry Silberman gave a very good argument in favor of that in the way in which he approached it.
Bill Galston, it does seem that Larry Silberman was riding this hobby horse, really, because he talked about the dominance of liberal media as a threat to American democracy, and he went on to blast the New York Times and the Washington Post as Democratic Party broadsheets, or virtually Democratic Party broadsheets. And he said, nearly all of the press leans to the left, which of course is, in terms of reach, is not quite right anymore. It's a little bit outdated. But he went on in this vein. Do you think that it just strikes me that that altering libel law, whether that's a good idea or a bad idea, would have very little effect on the complexion of the press. Don't you agree?
I do agree, because we're in the grips of a larger problem, which I think explains why this particular controversy has surfaced now. And that is something we've discussed many times before, the collapse of media gatekeepers all around. And that is true, unfortunately, for larger news organizations, as well as for smaller ones, more eccentric ones, individual bloggers, etc. I'm afraid that editors are letting through uncorroborated statements that never would have passed editorial muster 20 or 30 years ago. And many more false things are being said by many more people than was the case when I was younger. I'm convinced of that. And so if there aren't gatekeepers within media organizations, there's naturally going to be pressure to expand protections for individuals in other ways, including the framework of libel laws. I am not saying that it would necessarily be a good idea to do that, but I think we have to begin by understanding why we're having this conversation right now in this way. And although I can't go into details, I've been dealing very, very closely in recent weeks with someone who has arguably been libeled by people who had the responsibility uh, to get it right and either negligently or deliberately did not. I mean, this is a big problem. And
Mhm.
when I look at people who've been on the receiving ends of this, I really say, boy, there, but for the grace of God go I, because if some of my columns in the Wall Street Journal offended people who were determined to damage me personally in response, they could do so. What recourse would I have? Houston, we have a problem. I don't know how to solve it, but we have a problem.
Damon, one of the things that strikes me as I read Judge Silberman's dissent is that for many years I shared his views completely about the bias of the press and all of that. I mean, I think it was undeniable that the majority of the sort of mainstream old line major news organizations lean to the left, or at least center left, and that there was definite bias in the way they framed things. But it's amazing to me to see that they just ignore the fact, that is, Silberman did and virtually did, and Thomas too, that there has grown up in the last 25 years a huge right-wing media entertainment sphere that is supposed to provide the balance, and yet the level of lying and blatant disinformation that comes out of these new right-wing outlets it just dwarfs anything that came out of the old line left-leaning media. And I just find the conversation a little bit one-sided.
Of course. And, I totally, I'm on board with Bill's way of trying to frame this in terms of a broader problem of kind of the spread of sloppiness and sometimes deliberate disinformation from ostensible news outlets. But I also think it's important to remember that the real impetus for this, now Eugene Volokh can clarify this by telling us after I've finished making my point about whether there is actually a longer legal critique that precedes this event. But I called up here because I remember this story vividly at the time. I'm looking at a story from Politico, February 26th, 2016. Headline, Donald Trump, we're going to, quote, open up libel laws. I remember when he started saying that during the Republican debates. And I remember thinking at the time, what the hell is he talking about? What I've never heard any Republican ever talk about, what the list of problems of America are. Near the top is our libel laws are too restrictive. I can't sue enough people for saying things I don't like. Well, why was he saying it? Because this is the way Trump has run his business. He runs a very shady series of businesses, and in order to get away with what he gets away with, he threatens and then actually does sue lots and lots of people. And that keeps them in line. And his vision of the American public life will be one in which any time a mainstream media outlet says something about a Republican that Republicans don't like, they will either sue or threaten to sue them to get them to shut up. And as we've seen with a lot of the cancel culture stuff, we know that corporations are very, very concerned with the bottom line and will button their mouths, cut contracts with people that they're dealing with if they're afraid that those people will bring them financial pain. And so this is a way of getting the critics to shut up about the right. And the fact that after Trump got elected, the mainstream media actually made his case for him far better is, well, that's the dialectics of our populist age. And we've seen it on multiple fronts where Trump says something that sounds totally outrageous, and then in reaction, his opponents confirm the validity of his initial provocation. But the fact is, this is a made-up problem, in my view. This is made up by a media ecosystem and its political defenders and those who benefit from it, who want to bully an independent press even more than they already do. So I have really no sympathy for this whole reformist move. And the fact that we now have judges and Supreme Court justices coming along is another sign of how Trump has managed to shift the terms of debate on a whole range of issues.
Can I chime in there? Because I think it may be
Sure.
helpful to think a little bit about the facts of the McKee versus Cosby case, which is where Justice Thomas expressed his skepticism about New York Times v. Sullivan. So what happened was Cosby there was Bill Cosby. And even though it's framed as McKee versus Cosby, I'm sorry, it's McKee versus Cosby in the Supreme Court because Cosby had, in response to an accusation against him of rape by Catherine McKee, basically called her a liar. And she sued for libel. And her case was thrown out because she was a limited purpose public figure. I don't see Donald Trump within a mile of that one, except insofar as to the extent that Trump has been accused himself of sexual misconduct, he might be viewed as more like Cosby in this respect, right? So Justice Thomas wasn't chiming in on this because, or at least on the face of the case, it didn't have anything to do with Democrat versus Republican issues. It had to do with the question of whether traditional, and to Thomas, tradition matters a lot and original meaning matters a lot, whether traditional rights to recover for injury to reputation should be restricted by the First Amendment, and if so, how much? And indeed, this debate is much older than 2016 on the court. As I mentioned, Justice White had been beating this drum since at least the mid-1970s, and likewise, there had been some conservative justices, Chief Justice Berger and Justice Rehnquist, who had made similar arguments. In fact, interestingly, one decision cutting back in some measure on New York Times v. Sullivan, or perhaps not extending it further, was a Gertz v. Robert Welch, where the defendants were a John Birch Society publication, so an ultra-conservative publication, who were accused of libeling this lawyer who had actually had sued a police officer for police brutality. And the John Birch Society was accused of libeling him, and it was mostly the conservatives on the court who said this is a kind of libel claim that should be able to go forward, not subject to the actual malice test, because this lawyer isn't really a public figure. So, Donald Trump was a political animal, and everything he does is for political reasons. But this debate about what the right balance is between reputation and free speech, and again, I am actually more on the traditional Justice Brennan side of this debate. He was the author of New York Times v. Sullivan, saying there ought to be very broad protection for free press. I'm skeptical of Justice Thomas's position, but it's not about politics as such. And as we see in the Dominion case, it could be very well liberals suing conservative media and conservative speakers.
Can I just chime in with one question? Isn't that, based on your description, the McKee case, isn't that an example of somebody who was wrongly held to be a public figure? I mean, because she was libeled and defended herself, therefore she became a public figure?
Well, you agree then with Justice Thomas, because that was part of what he said. Part of what he said was that she shouldn't be viewed as a public figure. But on top of that, he said also part of the problem is this entire public figure, private figure edifice that the court has built up. I will say, though, remember, McKee versus Cosby, McKee had accused Cosby of raping her some decades before. The statute of limitation had passed, so he couldn't be prosecuted for that. But she thought at least she could go public with it. So that what made her a public figure is that she deliberately sought out media attention for her positions. And under the court's case law, that's a perfectly plausible result. But again, I'm seeing a lot of libel cases in these kinds of claims of sexual assault, sexual harassment, and the like. Sometimes it is people who say I was falsely accused of sexual assault, suing their accuser. Sometimes it is people who say that they were indeed assaulted, and then the assaulter denied it publicly in a way that is itself libelous. There's a vast range of libel cases out there. A few of them are highly political, but really very few. By and large, these are cases where you've got individuals or businesses who claim their reputation had been injured, often for non-political reasons, and even when it's political, it's often not sort of sharp left-right. And to focus just on kind of the highest profile issues, which often are the political ones, because that's what hits the news, I think misses the big picture.
Okay, I see Linda and Bill both wanted to get in on this topic, but we're running long and we need to get to our third subject. So unless you have a really short comment, I would say let's save that and move forward. Okay. We have seen over the last few months that in a number of states, Republicans are passing anti-riot legislation. At least 3 states have done so. Most recently, Florida. Ron DeSantis signed the Combating Public Disorder Act, which will broaden the definition of what a riot is. And will include, in a couple of cases, some of these laws have even included details like providing, 2 states want to provide immunity for drivers who strike pedestrians who are blocking a roadway. In Florida, it would just, let's see. The Florida case doesn't give them immunity, but it changes the let's see. It tones down to minimize civil liability for the offense. So let's begin with you this time, Damon. What do you make of these anti-riot bills? The ACLU says that they are attempting to criminalize free speech and protest.
Well, I mean, I guess it harmonizes with the point I was trying to make about opening up libel laws, that this is, again, the kind of Trumpification of the conservative side of our debates. A general irritation with what happens when you have a kind of maximally libertarian public square where people can say what they want, even at the risk of transgressing the truth and what opponents believe is right. And then in this case, public protest. Now, I'm let me be clear. I'm very anti-riot. I don't like riots. I don't like burning down stores and people's businesses and homes and parts of cities. I think it's terribly counterproductive and it violates rights and laws in all kinds of ways. And I think it should be prosecuted. I think what Portland permits to happen on its streets so very often, sometimes every single day for months on end, is an outrage and should be stopped under existing laws, which it could be. But these new laws are attempts to both court favor with members of the right who are kind of up in arms and outraged about the unrest of the past year, and then to kind of claim the mantle of being tough law and order people. And when it comes to DeSantis, very much plays into his hopes for 2024 as a presidential candidate to anoint himself successor to Trump. And so I think it's on the whole, it's bad. It's like Trump's invocation of opening up libel laws in order, I think, to quash critics preemptively. I think this is an attempt to create an incentive structure where people will be more inclined to not go out and protest for fear of, say, being, I don't know, run over by a car, where the person who does it, as you said about the Florida change, Mona, could result in the driver doing it, thinking, I'll get away with this. They won't be able to sue me for it because I'm now protected to run down a protester who's blocking my path in traffic. And again, let me be clear that I don't love when protesters shut down roads and highways for the sake of a protest. I think it's very easy for protests to backfire in terms of public opinion by inconveniencing people. I often think that protests are about blowing off steam more than actually changing anybody's mind. It's not the way I prefer politics to be done. I'm not a romantic about street protests and their efficacy. But it is, in my view, a mark of a truly open society, a liberal society, that you have a very open public square with robust speech and rights for speech and demonstration and expression of political dissent. And I bristle at the notion of narrowing those standards.
Professor Volokh, there are laws on the books that prohibit arson, that prohibit property destruction, that prohibit assaulting police officers, many of these things. Do we need more laws on those subjects, or what's your view?
I think it's really hard to answer this in the abstract, right? That there's always a question of what's the best way of enforcing the laws, what the penalties should be for various crimes, how various crimes should be defined. I totally agree that riot is an tends to involve extraordinarily serious crimes, which cause extraordinary damage and lasting damage to the communities, including completely innocent members of the community. And I also think that protests are constitutionally protected, must remain constitutionally protected. But there is a difference between riot and protest. Riot generally involves violence. The Florida law, for example, is targeted at riots that involve not just crime but violence, whether it's an improvement over existing Florida law or worse than existing Florida law, or doesn't really make much of a difference existing Florida law, I think you'd need to look closely at the existing scheme and how well it's being enforced and the like. I'll give an example. There's a provision in the new statute, in the new bill, that criminalizes mob intimidation. And that makes it a crime to use force or threat of force to compel or induce another person to do something or to maintain a particular viewpoint, to kind of say something. Is that already criminal under Florida law? Maybe under certain circumstances, probably. But is it a good idea to make it expressly a crime? It may very well be. So it's hard to talk in the abstract. Do we need more laws? It may vary from state to state. It may vary on the particular, based on the particular law that's being proposed. As to the civil immunity, which is a relatively new thing, although not entirely new, what it says essentially is that if somebody is involved in rioting, not just in protests, but in rioting, and riot is defined as being basically involved with other people to engage in violence or threat of violence, essentially, then in that case, they cannot recover civil damages if they're injured in the course of this rioting. There could still be a criminal prosecution against the injurer, but they can't recover civil damages. That I think reflects in some measure existing standards that generally speaking, in a civil case, you're going to have at least a lot of defenses, say, in a negligence action against somebody who is himself acting criminally. Defendants who are criminals rarely prevail in these kinds. Plaintiffs who are themselves criminals rarely prevail in these kinds of cases. But also it adds to the reality that a lot of people who, when they're surrounded by an angry mob who's not letting their car go forward or often even go backwards, they really feel themselves understandably threatened, thinking back on things like the Reginald Denny beating and various other such incidents. So in some measure, I think it's a recognition of a desire on the part of many people for a sort of self-defense against what is perceived as a kind of kidnapping with threat of violence. So whether that's a good idea or not, that's worth talking about. But I think at the end, it's hard to talk in general about whether anti-riot laws are or are not a good idea without looking specifically at each particular provision and how it compares to existing rules in that state.
Linda, you had your hand up.
Yes, well, let's just say I have a totally different view of this. These laws are not being passed in a vacuum. They are being passed because of what we have experienced over the last several years. And by the way, it didn't just begin with the protests after the George Floyd killing. If you go back to the Charlottesville protest, where you had competing groups, some sort of neo-fascist groups wanting to protect Confederate statues. And you had others who wanted to see those statues come down. These turned into violent protests, and a man ran his car into a crowd of protesters, killing Heather Heyer in 2017. So, we've had these kinds of incidents, and to suggest that somehow this is just a sober rethinking about whether or not, likening it to the Reginald Denny killing, which for listeners not old enough to remember this was during the LA riots. I believe it was 1991, sometime in that time framework after the Rodney King beating had occurred, and there were widespread riots in the city of Los Angeles. And a truck driver found himself in South Central Los Angeles, was taken from his truck and very badly beaten during that. These laws are not being passed because of that kind of outrageous incident. They are being passed as a way to try to deter people from taking to the streets and protesting. And there already is a lawsuit that has been filed in the Florida law that has just been passed. A lawyers group has filed suit in federal court alleging that that new law is unconstitutional, and I'm sure there will be others. But I just think it's disingenuous to suggest that somehow this is well-considered legislation that's maybe closing some loopholes where people are getting away with bad behavior and there's no way to prosecute them. There are plenty of ways of prosecuting people who are actually committing violence, who are actually interfering with the rights of others. And these laws seem to have a totally political purpose, and it is sort of interesting that they are only occurring in states where Republicans are in control, and it's kind of a backlash to the kind of social protests we've been seeing, and we have to recognize it as that.
Bill Galston, one feature of this legislation in Florida is that it will make taking down a monument, even a flag, I imagine, a second-degree felony with up to 15 years in prison attached, which would make it akin to the crime of rape. Now, the left comes under a lot of criticism, and deservedly so, for saying that speech is violence. And yet this Republican law basically is saying that symbolic speech, tearing down a statue. Now, admittedly, one shouldn't tear down statues. I'm against iconoclasm, but to say that it is a crime, that it should be punished with such severe penalties comparable to a violent felony is really the right adopting the same position as the far left, saying, "Yep, speech is violence."
Well, I have to say that when statues of Lenin and Stalin came tumbling down in the late 80s and early 90s, I sort of liked iconoclasm.
Well, yes.
So I'm not against it. I'm not against it across the board. Look, we can argue about the details, but this is a very old story. Two wrongs usually make things wronger, and this case that we're now this question that we're now discussing is no exception. I noted with interest that a member of the Florida legislature, in arguing for this legislation, said we don't want Florida to turn into Seattle, and we don't want Florida to turn into Portland. And what we had in those two cases was the failure of city governments who were sympathetic to the protesters from enforcing laws that were already on the books. And that, in my judgment, is 99% of the problem. Except at the margins, we don't need new laws. We need municipal governments and governments at every level who are prepared to draw a bright line between permissible forms of protest on the other and violence on the one hand and violence on the other. And when that doesn't happen, it invites excessive reactions, such as we're now seeing spreading across the country. And politicians who don't speak up in favor of enforcing the laws that etch that bright line are sowing the wind, I'm afraid, and we are now reaping the whirlwind. We cannot treat protests based on our sympathy for the object or the goal of the protest without risking a huge backlash, which is what we're getting.
All right. We now come to the segment of the program where we highlight or lowlight something that from the past week. And Linda Chavez, let's start with you.
All right. Well, I'm going to point to an article that appeared this week in the New York Times by Thomas Edsall. It's called Why Trump is Still Their Guy. It goes into the role that Trump still plays in the Republican Party. But what makes this article somewhat different than just sort of going through talking about the stranglehold that Donald Trump still holds on the Republican Party is it points to some very interesting academic studies that look at the question of collective victimhood. And as we've talked about on the show many times, many of Trump's supporters feel that they are victims and they feel that they are being replaced. Tucker Carlson plays into this theme often, that they are being replaced by people less worthy than themselves. And what Edsall does in this piece is to talk about some studies on the notion of dominant group victimhood. And I recommend it. There are some links to some long scholarly pieces, which I followed, and I would recommend the same to our listeners.
Thomas Edsall is always worth reading. Thank you. Damon Linker.
Well, I'm going to do what I've been doing more and more lately in this segment, and that's point to a Substack. And I promise it is not because I am strange and read a lot of Substacks. It's that people link to things and it ends up being on Substack. And it's just, I think, a fact that some of the most interesting stuff is being done on that platform because it permits people to write outside of the somewhat narrow strictures at a lot of journalistic outlets these days. So my selection this time is a long post by a guy I've never heard of before named Richard Hanania. He apparently is a research fellow at the Saltzman Institute of War and Peace Studies at Columbia University. Wow, who knew? He has a piece titled, Why is Everything Liberal? And it's really, really good. A very interesting attempt to apply kind of
Excuse me for one second, Damon. Sorry to interrupt. Jim Swift, I'm getting a red pop-up. Problem saving local backup of audio. Yes. Okay. I'm sorry, Damon.
That's fine. I'll back up a sentence or two.
Okay.
So, yeah, that's Richard Hanania, who I had never heard of before. It sounds like an interesting guy, but this piece is titled, Why is Everything Liberal? And it's really interesting. The subtitle gives you a sense of where he's coming from. Cardinal preferences explain why all institutions are woke. This is basically an attempt to apply kind of vaguely game theoretic ideas. There's no math in it, though, I promise, to the question of why so many institutions in American life lean left. And the short answer is that basically, the more powerful political faction will always be the one that has the more passionate activists in it. And there are simply more passionate activists on the left than on the right. And this should make a kind of intuitive sense. One of the views of conservatives, whether of the old-fashioned kind or the more Trumpian populist kind, is that in the scheme of life, politics is not the most important thing. Other spheres of life are more important: business, family, faith, things like that. Well, that translates into the fact that there are simply fewer people on the right who make politics the most important thing and back it up with donations to parties and movements, and also behavior in various ways in their lives and within institutions. And so the end result is that the left takes over more institutions that it gets involved with because there are more people who care enough to try to do exactly that. So very interesting, very stimulating, and definitely worth thinking with, and perhaps against, but again, as a goad to thinking, it's great.
Excellent. Professor Volokh, we don't require our guests to have a highlight or lowlight, but if you have one, you're
Sure.
up now.
Sure. So there's a story in the news about a police lieutenant who works in internal affairs, or worked in internal affairs for the Norfolk, Virginia Police Department, who was fired because it came out as a result of what it seems to have been a hack of a crowdfunding site, that he'd donated $25 to the defense fund for Kyle Rittenhouse. Kyle Rittenhouse, of course, is being prosecuted for murder because he, at one of these protests, he shot a couple of people. He claims it's self-defense. You know, maybe it is, maybe it isn't. There hasn't been a trial yet. And this police lieutenant was was helping fund, again, to the tune of $25, the defense. And of course, in America, everybody has a right to hire a criminal defense lawyer. The officer also included a message that says, "God bless, thank you for your courage, keep your head up, you've done nothing wrong." Now this has come out, and now this officer is fired. And the one thing that keeps coming back for me is, you could imagine exactly this happening in 1950 with somebody who works for a police department or elsewhere, contributing money to someone who's being prosecuted for committing some crime, who's on the communist side, or who was seen as a communist, or a maybe communist, or whatever else. And somebody in 1950 thinks this person really isn't a communist, or thinks this person isn't really guilty, so he figures, I'm going to do what I can to do what? To just fund this guy's criminal defense, which, again, everybody's entitled to. Would have been fired then because of the blacklist and the surrounding Red Scare. Being fired now. Now, maybe on balance, this should tell us that the conventional wisdom about the McCarthy era may be not quite right. Maybe, in fact, it makes sense that we want to make sure that people who work for the government and in positions of authority aren't sympathizers to a murderous, democracy-destroying regime. Maybe it makes sense today that anytime a police officer supports somebody who's perceived as a criminal, even though, again, there's been no criminal trial yet, or is perceived as racist, then that person should be fired, or maybe it should be limited to police lieutenants. You can imagine that distinction. But the message that's coming out from this, it seems to me, to the public at large is, better not say anything, better not give any money to any cause that might get you tarred this way. Even if you're trying to do it anonymously and confidentially, there are hackers who might break in. Then it gets publicized, then it's on the news, and then you lose your job. And not only do you lose your job, presumably, once it's in the news, you don't get another one either. So we are seeing in many ways, not exactly the same, nothing is ever exactly the same as in history, but we're seeing in many ways a replay of parts of the 1950s with blacklists, with creeping definitions where communist became communist sympathizer, became fellow traveler, became anybody who's roughly on the left, just like with racist and white supremacist being redefined to cover a very wide range of ideas. And, again, we could say maybe that's worthwhile. Maybe we don't want criminal punishment for bad ideas, but we do want social ostracism and professional destruction. Maybe. But it's interesting to see just how much of today is an echo of that aspect in the 1950s.
Thank you. Bill Galston.
Yeah, a former colleague of mine at Brookings named Jeremy Shapiro, who's now a senior official in a European think tank, just published a very interesting article in Foreign Affairs. The thrust of which is that the Biden administration, sooner or later, is going to have to make some choices in foreign policy that it has refrained from making up to now. He specifically poses the following question. If Joe Biden has promised a foreign policy for the middle class, is that compatible with the traditional assertion of American leadership around the world, which calls upon us to do many things that may not serve in any direct way or may even undercut the interests of certain portions of American society, like the middle class? And Jeremy's point is very simple. I'm not sure I agree with his bottom line, but his point is simple. In this, as in other areas, the Biden administration has adopted an all of the above declaratory strategy that glides over the fact that there are fundamental tensions or even contradictions among pieces of what Joe Biden, the candidate, and the president has pledged to do. And at some point, choices will be unavoidable, and it's not clear that the administration is ready to make them.
Okay, thank you. I'm going to hail a piece that appeared in the Washington Post by Cornell West and Jeremy, let's see, I didn't get his last name. Jeremy Tate, there it is. It's called Howard University's Removal of Classics is a Spiritual Catastrophe. So Howard University, arguably the leading historically Black college in the United States, has decided to disband its classics department. And West and Tate write, Frederick Douglass risked mockery, abuse, beating, and even death to study the likes of Socrates, Cato, and Cicero. They note that Martin Luther King Jr. included 3 references to Socrates in his letter from a Birmingham jail. And they go on to say, look, this is not happening in a vacuum. This is the result of a massive failure in this nation to substitute what they say is schooling for education. That is, just the mere acquisition of skills and jargon. And they say schooling is not education. Education draws out the uniqueness of people to be all that they can be in the light of their irreducible singularity. It is the maturation and cultivation of spiritually intact and morally equipped human beings. Highly recommend it. Hope that Howard will reconsider this would be a tragedy for education in general. So with that, I want to thank our guest, Professor Eugene Volokh. I want to thank all of you for listening, and we will return next week as every week.